Judgment in the matter of an application by Lorraine Gallagher for judicial review, Northern Ireland, and R on the application of P, G, and W versus Secretary of State for the Home Department and another.
Lord Sumption will explain the decision of the court.
These 4 appeals are about the system for disclosing criminal convictions, cautions, or reprimands to potential employers. In all 4 cases, the respondents have been convicted of or have received cautions or reprimands for comparatively minor offending. One of them received a caution many years ago at a time when she was suffering from undiagnosed schizophrenia for stealing a sandwich from a shop, and shortly afterwards received a conditional discharge for stealing a book worth 99 pence and failing to surrender to her bail. A second respondent was convicted, again long ago when he was a schoolboy, of assault occasioning actual bodily harm. This is sometimes a serious offence, but in this case it arose out of a fight with some other boys on the way back from school and resulted in his receiving a conditional discharge. A third respondent was reprimanded for consensual sexual activity when he was only 13 years old with 2 younger boys. He received a police reprimand because the Crown Prosecution Service considered that the offence was in the circumstances too minor to justify a prosecution. The fourth was convicted on 2 occasions of failing to wear a seatbelt while driving or failing to ensure that children in her car were wearing seatbelts. The disclosure of the respondent's records has either made it more difficult for the respondent to get a job or may make it more difficult in future. All the respondents complain that the statutory scheme governing the disclosure of criminal records operates in a way that is unfair to them and is inconsistent with the European Convention on Human Rights. Article 8 of the Convention protects the right to private life. It is not disputed that the disclosure of a person's criminal record does invade his private life, and it must therefore be justified by reference to some broader social purpose. The statutory scheme governing the disclosure of past offences in England can be shortly summarised. In 1974, Parliament passed the Rehabilitation of Offenders Act, a landmark enactment which provided for all but the more serious criminal convictions to be spent after a specified period of time. The Act was designed to enable those who had committed offences and served any period of imprisonment imposed on him to put their past behind them. It made a major contribution to the reintegration of former offenders into society. But the Act is subject to a number of exceptions for cases in which a former offender is asked about his criminal record in order to assess his or her suitability for some particularly sensitive occupation or activity, such as working with children or vulnerable adults, or membership of a profession calling for particularly high levels of integrity and public confidence. In these cases, not only must the former offender tell the truth if he or she is asked about the convictions, but a certificate recording them will be issued on application by the Disclosure and Barring Service, a public body whose statutory function under the Police Act 1997 is to issue criminal record certificates when they are required for proper purposes. The operation of both of these statutes is mandatory. If the conditions for disclosure are satisfied, then disclosure must be made. There is no discretion. These statutory schemes raise problems of great difficulty and sensitivity because they turn on 2 competing public interests. One of them is the rehabilitation of offenders. The other is the protection of the public against people whose past record suggests that there may be unacceptable risks in appointing them to particularly sensitive occupations. The Bishard inquiry into child protection and vetting procedures after 2 young girls had been murdered by the caretaker at their school was a stark reminder of the importance of ensuring that the rehabilitation of offenders does not undermine proper standards of public protection. Under Article 8 of the Human Rights Convention, In order to justify an interference with a person's private life, two conditions must be satisfied. First, the interference must be in accordance with law. I shall come to the meaning of that expression in a moment. Secondly, the law in question must be necessary in a democratic society for some legitimate purpose, such as public safety, the prevention of disorder or crime, or the protection of the rights of others. In other words, it must be a proportionate response to a serious potential problem. In each of these appeals, the Court of Appeal has held that the current statutory schemes fail both tests. Essentially, this was because the law does not sufficiently distinguish between convictions and cautions of varying degrees of seriousness or relevance. The Supreme Court has taken the opportunity of these appeals to examine the extensive case law of the European Court of Human Rights and the domestic case law on these questions. It has concluded by a majority of 4-1 that, contrary to the view of the Court of Appeal, the current law in England passes the first test. It is in accordance with law. But it agrees with the Court of Appeal in 3 of the 4 cases before us that it fails the second test. This is because it goes further than is required to address the problem of appointments to sensitive occupations. It is, in other words, disproportionate. It should be emphasized that the great majority of cases where criminal convictions must be disclosed involve much more serious offending than these cases and are unlikely to be affected by today's judgment. At its most basic, the expression in accordance with law means that there must be a legal basis for disclosure. No one doubts that there is one in these cases. It is provided for by statute. But the expression also refers to the quality of the law that authorizes the disclosure. In the view of the majority of this court, the relevant law must be accessible and foreseeable in its impact on the individuals affected. To be accessible, it must be publicly available and capable of being understood. To be foreseeable, its application must not depend on the discretion of those who apply it, unless that discretion is subject to clear principles which enable its impact in any given case to be predicted, if necessary, with the aid of legal advice. An inflexible scheme, like the ones with which we are concerned, may be open to criticism on the ground that it is disproportionate, but it should not fail the test of being in accordance with law just because it is inflexible. The statutes with which we are concerned are complex, but entirely clear in their effect, and are not subject to the discretion of those whose job it is to apply them. They are therefore in accordance with law. Turning to the question of proportionality, the second question, the critical point in the view of the majority of this court is that this is a case in which it is necessary to legislate for disclosure by reference to categories of case rather than by reference to the facts of each individual case. There are a number of reasons for this, but 2 may be mentioned here. One is that the only person in a position to make a balanced judgment of the significance of the facts of each individual case is the potential employer, because only he knows all the requirements of the job, and he can only do that if he has the information. The second is that the candidate with a criminal record needs to know at the time of his application for a job what, if any, convictions he must disclose if asked. He cannot wait until the Disclosure and Barring Service has considered the facts of his particular case. Certainty is particularly valuable to all parties in such cases. Once it is accepted that the law can properly require disclosure by categories of case, it is inevitable that the design of the categories will operate harshly in some cases which come very close to the dividing line. The present appeals are all, in one way or another, examples of that. The real objection to the disclosure rules affecting these respondents is not that the statute operates by categories, but that the categories chosen are said to have been badly designed. A great deal of thought went into the design of the categories of disclosable conviction, and in most respects they are acceptable. But so far as relevant in these cases, there are 2 features of the disclosure rules which this court regards as disproportionate. One is the so-called multiple convictions rule. If a person has more than one conviction, then his entire record is disclosable, however minor the offence, however widely separated in time, however long ago, and happen regardless of the penalty, if any, imposed. The object of the multiple convictions rule is to identify those who have a persistent tendency to offend. But the absolute way in which it is framed means that a high proportion of multiple convictions will be disclosed, which are quite incapable of suggesting a persistent tendency to offend. The rule is therefore not an effective way of achieving its object. It achieves it occasionally by accident, but not as a matter of design. It cannot therefore be regarded as a necessary response to this particular problem. The other disproportionate feature of the scheme, in this court's view, is that it fails to distinguish warnings and reprimands administered to young offenders from other modes of criminal disposal. A reprimand, or youth caution as it's now called, counts as a criminal record, but does not involve the determination of a criminal charge. Its purpose is instructive and reformatory and not punitive. Its inclusion among the matters to be disclosed is therefore, as it seems to the majority, a category error. Since 2 of these 4 cases involve disclosure under the multiple convictions rule, and a third concerned a reprimand given to a young offender, the Secretary of State's appeal in those cases must fail, albeit on narrower grounds than those accepted by the Court of Appeal. In the 4th case, his appeal will be allowed.
Thank you. The court will now adjourn.